I think we're getting there. I think we're poised now for the issue to rise up to the level of the federal courts of appeals. We're going to have arguments in the 10th Circuit in April, the 9th Circuit around the same time or shortly thereafter. We're about to get into the 4th Circuit. There are also already cases pending, not on direct marriage equality, but on marriage recognition in the 6th Circuit. So circuit court opinions will be coming out over the next several months, probably in the summer, and assuming that states that lose will appeal, it looks like we will be petitioning the Supreme Court for review of marriage cases in time for the 2014-2015 term. I think we're going to be looking for whether courts use heightened scrutiny or some form of more demanding judicial review than the traditional deferential rational basis test in deciding these cases. We're going to be looking at how they characterize the issue under the Due Process Clause as involving a fundamental right, or whether they're going to focus primarily on the Equal Protection Clause, which is where most of the argument has been so far. It's sort of interesting that courts may characterize the question presented to them quite differently in the context of this situation. The Supreme Court's role has been very important because the lower courts, of course, are bound by what the Supreme Court says. The Supreme Court sets precedents. But in addition, the Supreme Court is, I think, the main engine in pushing society to accept new visions of civil rights in this country. The Supreme Court's role in Brown versus Board of Education in the 1950s was very, very important in pushing forward the civil rights movement. The Supreme Court's role in Loving versus Virginia in 1967, very important in pushing forward the right to interracial marriage and to open up the idea that marriage itself, that the choice of a marital partner is a fundamental right. And the court issued several important rulings in the succeeding decade, sort of expanding on that topic. The Supreme Court played an extraordinary role in the revolution about sex in the United States, in loosening up the extraordinary sort of Victorian era criminal law regulating sexual activity in this country. The Supreme Court made it possible now to have access to contraception, to abortion, to striking down laws that criminalize sexual activity outside of marriage. Some people would say for ill. Some people would say that it increased freedom tremendously. But the court took a leading role in striking down lots of criminal statutes that had impeded the ability of people to live their lives the way they wanted to live their lives. And the gay rights cases are just like a part of this. Well, the next big issue will be getting a national statute banning discrimination in employment and subsequently extending that to housing and public accommodations on a federal level. At the present time, about 40 to 45% of the country lives in states that ban such discrimination. But a majority of the population lives in states where there is no statutory protection against discrimination on the state level. And there may be municipalities in many of those states that ban discrimination, but it's not there as a matter of state policy. And it may be that there aren't too many more states where it will be possible politically to enact such prohibitions. But there is a bill pending in Congress which has now been approved once by the House in 2007, once by the Senate last year, that would add to federal law a ban on sexual orientation discrimination in the workplace. And I think once we have the marriage equality issue put to rest, which I hope will happen within the next year or two, there'll be an intense focus on getting that Employment Non-Discrimination Act passed.